Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, what is the difference of the effect of a liquidation on a director versus a shareholder? So before a company goes into liquidation, directors have certain duties under the Corporations Act. When a liquidator is appointed, the liquidator will review the director's behaviour and actions to see if there may be any significant breaches of those duties. One of the most well-known of those duties is the duty to prevent insolvent trading of a company. If a liquidator finds a breach of any of those duties, it does potentially open that director up to personal liability to the company. If someone is a shareholder only, they don't carry those same responsibilities that the director carries. Having said that, because they're not a director, they may not get as much say, or potentially not any say at all, over the operations and day-to-day running of the company. If the company goes into liquidation, it's most likely that the shareholding, so the value of the shareholder's shareholding, is of no value anymore. And the reason for that is a shareholding is a residual value after all the debts of the company have been paid. In a liquidation, the company is usually in that position because all the debts can't be paid, which means that the residual value of the shareholding is usually nil. One of the things to be mindful of whether someone is a director or a shareholder, though, is if they're receiving money from the company and payments from the company, could these potentially be subject to clawback by a liquidator? So it's important to find out, especially if the company is a little bit wobbly, the nature of the payments that you're getting, and if those particular types of payments could be subject to clawback, or if they're not of that clawback type.